Welcome to the deep dive. Today we're looking at a pretty explosive forensic investigation.
We are.
It details an alleged criminal conspiracy, and this thing apparently stretches back decades inside the Maori land courts.
Yeah, and the sources claim this was a systematic effort to disinherit legitimate landowners.
And they use one specific case, the Winikerei land case, as the blueprint for how it was all done.
That's the one.
Okay, let's unpack this. The investigation zeroes in on what the sources call a widespread criminal enterprise.
Orchestrated, allegedly, by a judge, Robert Preshaw Dykes, and his wife, Ruby Frances Victoria Bach.
And the genesis of this is supposedly all the way back in 1947. I mean, we're talking about alleged misfeasance in public office.
We are.
For those of us who, don't live in a law library, what does that actually mean here?
What means the source material is alleging that Judge Dykes wasn't just being careless. Right. He was allegedly using his judicial power maliciously, intentionally, for an improper purpose. And that purpose was basically theft and land consolidation. So our mission today is to really deconstruct that exact mechanism and then trace the flow of these allegedly stolen assets over, 77 years?
You mentioned the mechanism. The sources talk about a spousal shield. What was that?
That's where the alleged genius of the concealment really lies.
Okay.
The sources claim Judge Dykes used his wife, Mrs. Bach, as a kind of shadow clerk.
A shadow clerk.
Yeah, creating what they call a closed-loop domestic conspiracy. It just completely eliminated any independent court oversight. I mean, you can't have checks and balances if the person checking is in the next room.
And the specific act, this holiday raid, allegedly happened during a holiday lull, January 31st, 1947.
In a deserted courthouse in Mercer.
And that's when the key forgery happens, Minute Book Entry 30, Mercer MB 141. That was the entry that severed the Winikerei heirs from their land.
And what's fascinating here is how they hid the paper trail.
How so?
The land itself was in Mahia, but the order, the fraudulent one, was processed nearly 300 kilometers away in Mercer.
300 kilometers?
Yeah. The investigators call it geodetic displacement. It's essentially jurisdictional arbitrage, a deliberate move to make sure the victims would never even think to look for this ghost record.
So, with the record buried so far away, the legitimate owners were essentially made invisible. What was the immediate fallout from that? Who benefited?
Well, this fraud had a devastating double trajectory.
Okay.
On one side, the law side, the Winikerei lineage, was functionally just erased. They suffer what the sources call identity fraud.
So they were eventually classified as abandoned owners.
Exactly, because they had no idea their legal status had been tampered with.
And on the other side, the gain side.
The Hawatohera Kiriona estate was allegedly fraudulently enriched. The documents describe them as a favored compliant faction.
So they were in on it.
They allegedly colluded by providing manipulated genealogical information, which made the forgery look plausible on paper.
Right.
If we connect this to the bigger picture, this was achieved through the abuse of judicial power, specifically to consolidate land into the hands of this favored group.
So that initial 1947 forgery starts the clock on this 77-year asset laundering timeline. Mm-hmm. The land was transferred pretty early, around 1960, to the Fulton family, who are described as proxies, then to Isabel Creswell in 2017.
Yeah.
But the final step, and the sources say this happened just recently, April 5, 2024. The land was transferred to the Tatau Ote Wairoa Trust.
And this is what they call the most sophisticated step.
Bunkering the asset. Why does putting it behind a treaty settlement entity make it so much harder to get back?
It's a massive shield. By moving it to the trust, the asset is now protected by all the legal and political complexity around these post-settlement structures.
So it's not just fighting a private landowner anymore.
Exactly. You're now challenging an entity created under the Crown's own treaty settlement framework. It's a whole different battle.
Which brings up a core legal principle, I imagine.
It does. The entire chain of title, starting with that 1947 forgery, is what the sources call fruit of the poisonous tree. Meaning, since the original order was a crime, all subsequent titles are void ab initio. They are legally null from the very beginning. And yet, the legitimate heir's attempt to correct the record has been stalled for over 8 years.
So what does this all mean? The sources seem to be describing the 77-year failure to correct a crime not as an oversight, but as an ongoing passive cover-up.
A cover-up that protects the beneficiaries of the fraud.
And facilitates this final stage of asset laundering.
Right. The investigation is demanding the voiding of all these titles and, of course, the payment of reparations for 77 years of what they call compound economic loss to the Winikerei lineage.
It's an incredible story.
It is. And the key question this forces us to ask you, the listener, is this. Does 3 generations of systemic failure to correct a proven administrative fraud move the state from being merely negligent to becoming a functional co-conspirator through its prolonged inaction? That's something for you to consider.